Good morning, everyone. I do have one small item before we start the normal meeting, and that is to approve the request for the budget for the study we are starting today on Bill 273, which has been circulated for all members. Thank you, Madame Gladue. Do we?
Motion to approve.
Okay. Unanimous. Thank you so much. I love this. I hope it will continue throughout the morning. So I call the meeting to order. Welcome to meeting number 100 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order adopted by the House on February 14, 2024, the committee is meeting in public to begin its study of Bill C-273, an act to amend the Criminal Code, Corinne's Quest, and the protection of children. Today's meeting is taking place in a hybrid format pursuant to the House of Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. Those on Zoom have been tested, and it is in order. They have been tested for the sound. So first, I want to welcome Member of Parliament Peter Julian, member from New Westminster, Barnaby, and the sponsor of Bill C-273. Welcome to the committee, member. You have 5 minutes to present to the committee, and then it'll be followed by questions in the normal course from the members of the committee. La parole est à vous. Bienvenue.
The floor is yours. Thank you very much, Madam Chair. I'd like to say, to start off, that I am speaking from you, and we are doing our work on the unceded traditional territory of the Anishinaabe Algonquin people. It's very important to recognize this because now we are talking about the call to action number 6 of the Truth and Reconciliation Commission. So we need to keep this in mind at all times.
Bill C-273 is to repeal Section 43 of the Criminal Code, which gives justification to use force by way of correction towards children. Section 43 was codified in 1892, having descended from English common law, which allowed parents and schoolmasters to inflict physical punishment, quote, for the purpose of correcting what is evil in the child, close quote. Section 43 violates children's basic human rights to protection under the UN Convention on the Rights of the Child, which Canada ratified in 1991. And 9 years ago, the Truth and Reconciliation Commission of Canada called physical punishment, quote, a relic of a discredited past that has no place in Canadian schools or homes, and called for the repeal of Section 43 to remove the green light that has enabled so much violence against children. The research on physical punishment is robust. Physical punishment consistently predicts solely negative developmental outcomes, higher aggression, more mental health problems, slower intellectual development, weaker parent-child relationships. More than 75 peer-reviewed studies have indicated this, and I believe after I testify today, you will hear from Professor Durant and Ms. Butler, who will be able to speak more to that. Mild physical punishment easily escalates into more severe violence. Children who are slapped or spanked are 7 times more likely to experience severe violence than those who are not slapped or spanked. And Section 43 tells us that hurting another person is an acceptable and justifiable way to resolve conflict. Children who are physically punished are more likely to engage in dating violence and partner violence in later life because they have learned to respond to conflict with physical aggression. Parenting groups and teachers argue that Section 43 serves as a protection when they need to physically restrain a child. But the fences are already available to parents, teachers, and caregivers when they use force to defend themselves or another person. Section 34 of the Criminal Code. To protect property, Section 35 of the Criminal Code. To prevent the immediate commission of an offense, Section 27 of the Criminal Code. And in response to imminent peril or danger when there is no available legal alternative, which is a common law defense of necessity. There's strong support for change. 700 organizations across all sectors support repeal of Section 43. That includes all major organizations in healthcare, dentists, doctors, nurses, and all of the major organizations in Canada who have taken the development of kids as their fundamental role. And to date, 65 countries and 18 other regions have prohibited all physical punishment of children. In those countries where research has been carried out, there's been no increase in criminal prosecutions or child welfare apprehensions in minor cases. Decreases have been shown in support for and use of physical punishment. That is important. But why are we lagging behind banning physical punishment on children? My bill has also received support overseas. Members of this committee would have received from the following organizations in the past few weeks support for Bill C-273, including the International Human Rights Watch and the World Health Organization. We also have a number of international individuals who have written to this committee expressing support for Bill 273. And it's important to note that the countries or regions like Wales, New Zealand, and Ireland did not see an increase of prosecutions against parents and teachers since the passing of their legislation to ban physical punishment of children. Finally, I'd like to quote from Maurice Sinclair, the Honorable Maurice Sinclair, who spoke to this issue 7 years ago when we were looking at a previous iteration of the same bill. Maurice Sinclair said the following: "At one Indian residential school in Alberta, a teacher was charged with assaulting a student by punching him 3 times in the face, causing serious injury. The teacher had been convicted of assault at trial, but was acquitted on appeal by a court which held that the degree of force that he had used was reasonable. That case set the tone for how all children in residential schools was treated thereafter." It's time to repeal Section 43, and I look forward to your questions. Merci beaucoup.
Merci beaucoup.
Thank you.
Alors maintenant, on commence.
Now we're starting up the first round of questions, and we'll be starting with I don't have any names on my list here.
Okay. Mr. Moore.
Thank you, Madam Chair. And thank you, Mr. Julian, for being here today to present on your private member's bill. Unfortunately, at a time when there is skyrocketing violence in Canada, car thefts up 300% in Toronto alone, gang homicides up 100%, a dangerous opioid crisis, and just 2 days ago, a case involving child sexual abuse thrown out because of a horrific case thrown out because of vacancies in the court system. And those are all matters for which motions have been put forward for study at this committee. Instead, we're studying a bill, your bill, that would criminalize the behavior and the actions of loving parents and teachers who are trying to provide a safe learning environment for their children. Now, there's a number of things, Mr. Julian, a number of statements you made that I think could lead Canadians, in your opening remark, to the wrong conclusion about what is the state of the law in this country. What you neglected to mention is that Section 43 of the Criminal Code, which applies to parents and teachers, was considered by the Supreme Court of Canada. Chief Justice Beverly McLaughlin, writing for the majority, stated, "The decision not to criminalize such conduct is not grounded in devaluation of the child, but in a concern that to do so risks ruining lives and breaking up families, a burden that in large part would be borne by children and outweigh any benefit derived from applying the criminal process." That was Chief Justice Beverly McLaughlin when Section 43 was constitutionally upheld by our Supreme Court of Canada. Now, you made a number of comments, and I think that they are inflammatory comments in your opening remarks. One, you mentioned someone being slapped on the face. The Criminal Code, considering Section 43, said slapping someone is not protected under Section 43 of the Criminal Code. You mentioned a quote from Sinclair about someone being punched in the face. That could lead someone to the conclusion that Section 43 allows parents or teachers to punch children in the face. It does not. That would be criminal actions. You mentioned physical correction by teachers. The Supreme Court of Canada, in considering Section 43, specifically said that physical correction is available only to parents, not to teachers. Teachers are specifically prohibited from using physical correction on a student. So you have three pretty inflammatory statements in your opening, and I think that underpins this whole discussion. We need, and sorry to take up time, but I want to get the record straight on what the Supreme Court said Section 43 actually does. It says parents and caregivers can only use corrective force that is minor or trifling in nature. For example, spanking or slapping a child hard enough that it leaves a mark or bruise would not be considered trifling. The court said teachers cannot use force for physical punishment under any circumstances. A physical punishment cannot be used on children younger than 2 or older than 12 years old. Physical punishment cannot be used on a child in anger or in retaliation for something the child did. Objects such as belts or rulers may never be used on a child, or a child must never be hit or slapped on the face or head, which you mentioned in your comments. Any use of force on a child cannot be degrading, inhuman, or result in the harm or the prospect of harm. Mr. Julian, what Section 43 does is it allows a parent whose child is repeatedly trying to put their hand on an oven top, which would result in serious burns. It allows that parent, when the child refuses to obey any verbal commands, it allows the parent to maybe spank that child if that's how the parent chooses. It allows a teacher to break up a fight in their classroom. If you talk to teachers, and the teachers in my riding, they will tell you that there's increasing violence in the classroom. There's increasing situations where teachers have to intervene in violent conduct of students. Section 43 does not allow teachers to spank students, strap students. In Canada, that is strictly prohibited. Your opening comments would lead someone to believe that teachers under this can punch a child in the face or strap them. That is criminal activity. So I don't know how much time I have left, Madam Speaker, but it took a bit of time to set the record straight on what is the current state of the law. Section 43 is an important provision. It's in the criminal code for a reason, and it narrowly protects teachers who are trying to provide a safe learning environment and parents who are trying their best to raise their kids. Section 43 has been considered by the Supreme Court, has been found to be of significant value, and has been constitutionally upheld. So, Mr. Julian, I'll end by asking you, Chief Justice Beverly McLaughlin said, the decision not to criminalize such conduct is not grounded in the devaluation of the child, but in a concern that doing so risks ruining lives and breaking up families. Do you think Chief Justice Beverly McLaughlin has it all wrong and you're right?
Madam Chair, how much time is left after that very, very long 30 seconds? Well, I obviously that question was not intended to elicit information, but let's say the following. What Mr. Moore, you were neglected to say was it was a split decision. What you neglected to say was since that decision, over 60 countries have banned physical punishment of children. And what you neglected to say as well is both the Italian and Israeli Supreme Courts also ruled against corporal.
The question was,
you're not taking even more of the time.
No.
You took 5.5 minutes.
Mr. Moore, time's
is
up.
Beverly McLaughlin wrong and you're right?
Time is up.
Just answer yes or no.
I think, Mr. Julian, you're going to get a chance. Because, Mr. Moore, I think your time is up, so we're good. So why don't I now go to Madame Dillon? Madame Dillon?
Yes, good morning, Mr. Julian, and thank you so much for being here to testify about this bill. Could you maybe finish your thoughts from the previous question? Go ahead.
Thank you so much, Madame Dillon. I appreciate that. I do believe that committees should ask questions and then allow time for response. Perhaps I'm old school that way. Since that split decision of the Supreme Court more than 20 years ago, we have seen 60 countries ban physical force used against children. That includes almost all of our major allies. I cited Wales and Scotland and Ireland and New Zealand earlier, but Sweden, Finland, Norway, Germany, France. I could go on and list the entire list of countries that have gone in that sense. But the call to action, number 6, from the Truth and Reconciliation Commission is something that all parties around the table have committed to. They committed to implementing the calls to action. The reason why I quoted Murray Sinclair, who is well-renowned, is because of the fact that he spoke about the impacts of Section 43, which dates back to 1892. Again, we're not talking about fresh legislation. We're talking about something that comes from the 19th century. And the reason why there's been so much pressure to repeal Section 43 from 700 of all the major organizations in Canada, including all the major healthcare organizations, all the major organizations who are trying to facilitate development of our youth. The reason why there is such a consensus is because, and as we'll see in the second hour of the discussion, all the peer review science shows the negative impacts on children of allowing the use of physical force against children. And my final point is, as I mentioned at the outset, there are a number of provisions of the criminal code that allow individuals who are protecting children, who are defending themselves or another person, protecting property, to those sections of the criminal code apply. And so I find the argument of Mr. Moore, though I have a lot of respect for him, disingenuous, because the facts and the science prove otherwise.
Thank you, Mr. Julian. And we cannot deny that there is an increase in violence at school. But something interesting you mentioned was that corporal punishment upon children at a young age begets more violence. So these bullies at school, they come from somewhere. You don't just start bullying out of nowhere. So maybe you could speak a little bit more about the effects of corporal punishment on small children and how they behave in society. And I might run out of time, so you can have enough time to answer the question. What tools can teachers use to manage this kind of violence? And if we have any lessons to learn from other countries? Thank you.
Thank you very much. Those are great questions. First off, do we have lessons to learn from other countries? The countries I've cited, the 65 countries, 18 regions around the world that have banned the use of physical force against children, have done that because it is in their interests of their children and youth to do so. And so we've seen that evolution over the last 20 years. It's been a considerable evolution in ensuring that the children can grow and can prosper, and that loving support that comes from parents, from teachers, from caregivers can continue. The reality is, and as you'll see from the many briefs that this committee has received, science is very, very clear that there are a range of other tools available to parents and caregivers that do not involve using physical force. That is in the interest of the child. There is no doubt. And the final point I'd like to make is when we look at the organizations that have expressed support for this, whether it's the Canadian Medical Association, the Canadian Dentists Association, all of those organizations have been very, very clear about the importance of taking this step. At this relic from 1892, that it continues to be in our criminal code, that time has come to repeal it. And there have been various initiatives over the years. The Truth and Reconciliation Commission, I think, is the most notable, putting it as one of their first calls to action, call to action number 6, because of the legacy of residential schools. I think given the weight of the science, given the testimony that members of this committee are receiving from people who have done the studies, done the science about the impacts on children, I think it's fair to say that this committee, which is one of the leading committees in the House of Commons, should be looking to advance this legislation so that we can repeal Section 43.
30 secondes.
I
30 seconds.
to cite some of the organizations. Amnesty International Canada supports repeal of Section 43. The Anglican Church of Canada, the Canadian Academy of Child and Adolescent Psychiatry, Canadian Association of Social Workers, the Canadian Coalition for the Rights of Children, Canadian Council of Child and Youth Advocates, the Jewish Family and Child Services of Toronto, UNICEF Canada. These organizations are all calling for a repeal of Section 43.
Merci beaucoup, Monsieur Julian. Alors, Monsieur Fortin.
Thank you very much, Mr. Julian. Mr. Fortin, you have the floor for 6 minutes. Thank you, Chair. Good morning, Mr. Julian. Welcome to the committee. Section 43 is a fairly short and easy to read section. It talks about using force to correct a student or child in his or her defense. I understand from your argument and the references you cite that the action of correcting a child or imposing a punishment, we'll refer to that like that because that's what we're talking about today, well, the punishment is rejected today by the vast majority of countries around the world. And I would agree that, and I would say that I agree with that. When it comes to using force, we're talking about fathers, and mothers, and teachers. Our colleague, Mr. Moore, was talking about this, and Ms. Dillon was as well. There is a rise in violence in our schools. And we know that it can be useful or even essential for a teacher and sometimes a parent to use force to control rather than to correct a student or child. I'd like to hear what you have to say on this subject. In your opinion, can the use of force to control a child in certain circumstances, I'm not talking about punishment, that's settled and we agree, is the use of force to control a child useful or necessary in certain circumstances? Thank you very much, Mr. Fortin. In my opening remarks, I said that there are provisions in the criminal code that provide for the use of force to defend oneself or another person. This is provided for in Section 34. When it comes to protecting property, the possibility of using force is again provided for in Section 35. To prevent the commission of an offense or a crime, Section 27, once again, justifies the use of force. There's also a defense derived from common law, i.e. the state of need. This is in cases when there is no legal recourse. Force can also be used. So you're right, there are certain circumstances that require force. The reality is that these provisions are already in the criminal code. And as for Section 43, and many people across the country, including in Quebec, have long been calling for its repeal. Mr. Julian, are you familiar with the decision rendered by Justice Byrne of the Ontario Court on December 20 in R.V. Robert? Are you aware of this decision? I know little about it, but please do tell. In a nutshell, Judge Byrne accepted a defense under Section 43 for a teacher who had grabbed a child by the wrist, and because the child was becoming violent and they were afraid that he might assault another child, the teacher took him to the back of the classroom and released him once he was secure. The judge said that this is a good example of a situation where force can be used to control a child and prevent him from being a danger to himself or others. So I imagine that you agree with that decision. There are a few cases a year that use these kind of provisions. As you know, we don't have much time. Did you agree it, or did you not read it? What I'm saying is that it's not just Section 43 that's cited in the majority of cases. There are also Sections 27, 34, etc. Well, as for Section 43, I'd just like to know, do you agree with this ruling? You can tell me if you haven't read it. I don't want to force your hand. Well, I haven't read it, but in principle, when we look at this type of decision, because there's been a few over the years, the judges also use Sections 34, 35, and 27. They don't just use Section 43. Okay. Thank you very much. I don't want to rush you, but as you know, we don't have much time. If I properly understand, you agree that in certain situations, a teacher and parent can use reasonable force. Again, I'm not talking about punishment here, but the use of force to control a child. This is acceptable to you. I understand that we're talking about repealing Section 43, but on the principle of the use of force, I understand it is not your intention to prohibit parents or teachers from using force on a child when it is done, as Section 43 says, to the extent reasonable given the situation. I'm saying you're right, but what I'm also saying is that there are other sections of the Criminal Code that apply in this case. In defending this kind of thing, Sections 27, 34, and 35 apply. It's not just Section 43. That's my point. Thank you, Mr. Julian. Thank you very much, Mr. Fortin. Now, the floor will go to Mr. Garrison.
Thank you very much, Madam Chair, and I want to thank Mr. Julian for bringing this bill forward in the House of Commons. And there are parents groups in my riding who were asking me to do the same thing. And Peter had, Mr. Julian, I'll be more formal today, had already brought this bill forward. So there's significant community support in my riding for this bill. Mr. Moore raised the case of a Supreme Court decision, which I guess it's called the Canadian Foundation for Children and Youth versus Canada. And that was a decision of 2004. And he asked you whether you agreed with the Supreme Court judge. I'm tempted to ask, did you agree with the other three judges who disagreed with the Chief Justice in that case? It was a split decision. And there were certainly strong arguments on both sides made. And I wonder whether you agreed with the other judges.
I agreed with the minority in that split decision and found their judgment very, very compelling. And I think you're asking a very good question, Mr. Garrison. If this was before the Supreme Court today, 20 years later, I believe there would be a very different decision made. Now, what the Supreme Court has done is put it back to Parliament. And now Parliament decided on second reading by a clear majority to move this bill forward. It is now before the Justice Committee, very esteemed committee. And I think the approval in principle that came from the House of Commons directs the work of the Standing Committee on Justice. And so I would suggest that rather than going through the court system again, it takes a number of years with a different result, I believe, today. It makes sense for legislators who are given this mandate, were given the mandate by our constituents, to make the appropriate decision. And I was very gratified, as I believe most Canadians were, to see the second reading vote that allowed this bill to move forward to this committee.
Thank you, Mr. Julian. I certainly strongly believe that there have been changes in Canadian society over the last 20 years which would lead to a different outcome in the courts. And I wonder if you could talk a little bit about what you think has changed in terms of our attitudes toward violence toward children.
That's a great question, Mr. Garrison. First off, the science, as we've seen, numerous studies, 75 in the last 20 years, that have clearly indicated the negative impact of using physical force against children. That's the first evolution. Secondly, the number of countries around the world. There was only a handful in 2004. There are now over 65, plus 18 regions, including Wales and Scotland. I mean, these are our allies, these are fellow democracies that are all making the same decision. The court decision of the Supreme Court in Italy, the court decision of the Supreme Court in Israel, these are all indicators that are very, very clear and compelling. And 700 organizations, all the major health organizations, all the major organizations that work with children have all called upon Parliament to take this step and repeal Section 43. So what has changed is the groundswell of support and the science and the international evolution of thoughts about how the best way to ensure the development of our children and youth. And so all those things have changed since that decision, split decision.
You mentioned reconciliation early on in your presentation, and I guess I'll ask you if you share my concern that if we dismiss the arguments of First Nations people about this bill, we are in fact doing damage to the process of reconciliation.
I think you have absolutely hit the nail on the head, Mr. Garrison. The Truth and Reconciliation Commission put forward calls to action. It has been a number of years since the last call to action was implemented. This is a way for parliamentarians to step forward and ensure that we are moving forward on the calls to action. It has been 9 years since call to action number 6 was published. 9 years. And I cited Murray Sinclair speaking. This was after the TRC recommendation number 6, the call to action number 6 that Parliament did not follow through on. Now Parliament has the opportunity to follow through, and this would be a significant and important step for national reconciliation. Given what we know now about residential schools, it is an important symbolic and an important step for Parliament to take.
I know I have very little time, but I want to ask you about something which came up in my own riding, and that was in discussions with police who are forced to investigate family violence. And one of those officers said to me that they found this section problematic for their investigations, and that their investigation would be much easier if it was clear that violence against children is not acceptable. So in their investigations now, they have to consider the level of violence, was it appropriate, and all of these factors that make their investigations much more difficult. So this officer was a very strong proponent of your bill, saying it would make their investigations clearer and their explanations to families where violence has taken place much easier.
That is a very, very important point. Thank you, Mr. Garrison. The reality is child protection workers, police officers have found the very complicated nature of the split decision from 20 years ago difficult to enforce in terms of child protection. The confusion that comes out of that is something that I think is apparent to everyone. That's why the TRC recommendation was to repeal Section 43 to eliminate that confusion and to really start the process of reconciliation.
Thank you very much. We'll now move to our second round, and we'll begin with Mr. Caputo for 5 minutes, please.
Thank you, Mr. Julian, for being here. Frankly, if this law were to pass, it wouldn't impact me as a parent, but I'm not here as me. I'm here as somebody who's trying to ask you questions from a legitimate point of inquiry. And really, I want to get to the bottom of what do you believe should be criminalized? Because right now, to be candid, I think we're talking about a lot of extremes. For instance, you said there's a minority judgment, 6-3. I'm not sure which of the 3 minority judgments or the dissenting judges, if we want to be technical, you prefer. Do you have a preference as to which one you thought was right?
I think the preponderance of the split decision, the minority of the Supreme Court, when you read their decisions, it is very clear that their belief was that Section 43 is not justified in today's society. Now,
okay, well, when I read it, I look at it as 3 very different decisions. One said it was too vague, okay? Another said it couldn't be saved in relation to teachers, but not to parents. And one said it did offend it did offend the charter. And one of the reasons is that it was broad in relation to very, very slight use of force. So I with all due respect, I don't think we could just say, oh, the minority all got it right or the dissents all got it right, because they got to very different paths or to very different places in very different ways, with all due respect. So if we are going to correct the record, then let's be clear on that. I want to ask you this, Mr. Julian. If somebody were to symbolically correct behavior, which is what the Supreme Court talked about and what actually one of the dissenting judges talked about. Okay, I'm going to give you an example. Again, I just want to figure out what you believe should be covered. A parent who symbolically goes like this, 2 fingers. So should that be, would that offend the criminal law in your view? Sorry, I'll be more clear. Should that conduct be criminalized?
First off, I think your point about the Supreme Court actually reinforces the point of those who want to repeal Section 43. You're saying that there's a variety of judgments, the variety of statements in terms of that Supreme Court split decision, and that confusion, which you've just very clearly indicated, is a very, very eloquent testament to repealing Section 43. You've indicated the confusion, the differences, how confusing it is. And Mr. Garrison's point, yes, you did. You certainly did. I have a lot of respect for you, and I understand you do your homework, and you've just indicated one of the principal arguments for repealing Section 43, which is the confusion around that Supreme Court decision from 20 years ago, which Mr. Garrison indicated in his questioning, that at the same time, for teachers, for police officers, and social workers and child protection. Let me please finish. And child protection officers and workers. That confusion that you've just indicated is confusion that needs to be cleared up. Now, secondly, you're asking me to define the law, and that is not up to me. That you're asking a question that is not up to me. We are putting forward a call to action, and the Truth and Reconciliation Commission put forward that call to action to repeal Section 43. And so you are asking me to parse or to put in place some kind of provisions or interpretations around the criminal code, and I've cited them.
No,
Section 27, Section 34, Section 35.
Those are self-defense sections. I'm saying, when should a parent be subject to criminal law? That's why we're here. And my question is a parent who goes like this, 2 fingers is what I'm doing for the transcript, should that person be subject to criminal law? And to simply say, well, I don't know, that's up to somebody else to decide. With all due respect, we're here to talk about these very issues. And again, I'm trying to come here with an open mind, and that's why I'm actually asking this question, because you're the sponsor.
Okay, so let me ask you back. Is that done in anger? Is it done in anger? Is it done in anger?
It is, well...
Is it done in anger? Is it done in a way that...
It's done for correction.
Is it done in anger?
For correction.
And what extent of force is used? And here again, you're proving my point.
Because that's the extent of the force used.
In anger? Well, no, you're demonstrating something that you are not defining. Are you using force? Is it in anger? What is the circumstances? No, but these are all things that indicate exactly the point that I'm making.
Thank you very much, gentlemen. I will now move to Mr. Housefather for 5 minutes, please.
Thank you, Madam Chair. That was highly entertaining. I want to thank Mr. Caputo and Mr. Julian for providing that. And I'm going to come back to the decision in Children, Youth, and the Law versus Canada, because I wasn't planning on going down this line of questions, but given the previous questions, I think the right question is looking at the majority judgment versus the 3 minority judgments that Mr. Caputo was referring to. In the majority judgment, it states that you cannot use force against children under 2. Mr. Julian, is that written anywhere in Section 43?
No.
It also says you can't do it against teens. Is that written anywhere in Section 43?
No.
So it seems to me that the judges in that decision actually rewrote Section 43, not by Parliament actually intervening, as I think people who would be against the repeal of Section 43 would say it should be up to Parliament, not judges, to write the law. It seems that the law has been rewritten by judges in a number of ways. I won't get into all of the aspects of the majority judgment without Parliament actually having a say in this. Would you agree with that?
I would. And I think that is why the TRC, subsequent to the Supreme Court split decision, that has, I think, fair to say, caused confusion that continues to exist today. That is why the TRC made a very clear and unambiguous call to action number 6, which was to repeal Section 43. Because of the confusion that comes out of that split decision that Mr. Caputo has so eloquently spoken to and so eloquently demonstrated just a few moments ago.
I agreed, and I thought you very eloquently also demonstrated this, the 2-finger thing. Would you know, Mr. Julian, based on the Supreme Court judgment and based on the drafting of Section 43, whether that was or was not something that could have a legitimate defense under Section 43, given the Supreme Court judgment in 2004?
That is a very good question, Mr. Housefather, and that is indeed why I said you're asking me to cast judgment on something that has been very confusing, is confusing to child protection workers, confusing to police officers, and even confusing to the general public.
I believe in 1989, we adopted the UN Declaration on the Rights of the Child. And my understanding is that says that there should not be defenses related to corporal punishment. Is that correct?
Yeah, it was 1991, and that you're absolutely right to point to that, and the evolution of what has happened subsequently, and that is the evolution internationally of virtually every democratic state that values human rights. Moving to eliminate provisions of their criminal code that allow the use of physical force and physical punishment against children. And
countries like New Zealand, for example, which should be parallel, which did it in 2007, including in Scotland and Wales, which more recently did that.
You are absolutely right and well briefed. And when we look at European countries around the world, Japan, South Korea, South Africa, France, the list goes on and on. 65 countries, 18 regions meaning places like Scotland and Wales, that have a similar background in terms of common law, defense of human rights, concern about child development. All of those countries have moved in that direction. Almost all of them, since that Supreme Court split decision that has caused so much confusion, and which the Conservatives have so clearly demonstrated at this committee hearing. And so it is time to move forward on this, repealing Section 43, for the issues around truth and reconciliation, for the issues around child development, and heeding the call of 700 important organizations across the country who have all said with one voice, it's time to repeal Section 43.
And do I have any time left, Madam Chair, or is it? Madam Chair? 50 seconds. Justice Arbour, I believe, in her minority decision, stated that the section was too vague. It was unnecessary. That it should be unconstitutional because of vagueness. And I mean, reading that and then reading the majority judgment, I would tend to agree that this section does not give us clarity on what can and cannot be done. Would you be averse, Mr. Julian, if, for example, those who believe that there needed to be some clarity to replace this section, but not a defense like Section 43, would provide some kind of amendment to the bill?
I believe it is very important for a whole range of reasons to repeal Section 43. Now, I note that the Canadian Teachers Federation has said that they would like to see some changes to Section 265 of the Criminal Code of Canada, and I think that is something that the government could certainly look at. But the importance of repealing Section 43 goes beyond the fact that it's a statute that dates, or an aspect of the Criminal Code that dates from 1892. And so there are other ways of addressing that issue in other sections of the Criminal Code. As I mentioned, though, in the countries where they have stopped physical punishment of children, use of physical force against children, there has not been any increase in prosecution or cases against parents or teachers. That simply has not happened. There are other ways of looking at it in terms of the criminal code, and Section 265 should be looked at. Thank you.
Thank you. Monsieur Fortin, 2 minutes et demie.
Mr. Fortin, you have 2.5 minutes. Thank you, Chair. Mr. Julian, in 2.5 minutes. Earlier in the first round, I talked to you about the use of force to control a child. I understand we agree on that. Now, on the subject of correction, I have to admit that I'm a bit confused. In my opinion, you're right on some points, and on others, I'd like to hear a clear answer, because Mr. Caputo was saying earlier that a person who uses 2 fingers, for example, to slap a child's hand, telling him, don't touch that, don't do that, well, you know, that's one thing. I'm not sure I understand your position on this after all, but it makes me wonder, do we have to treat every use of force the same way? For example, I'm thinking of a teacher or a parent using a whip. When I was a boy at school, the principals would strike a child's fingers with a ruler. That was common. But today that would no longer be acceptable for all sorts of reasons, and whether it's in the criminal code or not, I think there would be some kind of public uprising. Mr. Fortin, one moment, please. There's an issue with Parleview. Just a quick pause for a few minutes.
right, let's resume with Mr. Fortin for 2.5 minutes, please. You can start over. Thank you, Madam Chair. Mr. Julian, before we were interrupted, I was saying that we looked at the use of force to control a child. That was discussed in the previous round. And now I would like to look at the corrective aspect. I was very interested in the question that Mr. Caputo asked earlier, whereby he said, you know, if you hit a child with 2 fingers on the hand, or that's one thing. And is that to be considered at the same level as, let's say, a teacher or parent who hits a child with a stick, or who strikes someone on the bottom or on the hand or in the back? Isn't there certain, how can I put it? Shouldn't there be a little discernment used with certain forces used? I haven't finalized my opinion here, Mr. Julian, but I think that we have to look here at criminalizing a behavior. So if someday a woman ends up in prison because she tapped her child on the hand, I think that that's not where we want to go. So I would like you to look at the different levels, the different grades of force, let's say. Should all uses of force be included in this? Well, no. You're entirely correct. The difference between taking 2 fingers and hitting someone on the hand and consistently striking a child are 2 different things. But as you are going to hear, and as you have seen in the statements that have been sent to the committee, there is this question of progression. Yes, if we say it's correct to use physical force to correct a child, well, it can get very serious. The reason there's so many groups, including in Quebec, it is a lot of child care representatives and healthcare workers who say that we should continue our work to repeal Section 43. And the reason for that is because it's not clear, it's confusing, and it can lead to more serious situations. But don't you think it would be better just to clarify it instead of simply repealing it? No, I'm sorry.
2.5 seconds, yeah. 2.5 minutes to Mr. Garrison.
Thank you for that expansion to 2.5 minutes from 2.5 seconds. You know, in this questioning, we've heard a lot about the Supreme Court decision, and it seems to be an attempt to say somehow that the 3 dissenting judges didn't agree. What they agreed was that Section 43 was unconstitutional, and I think just to review, there are different ways of getting there. Justice Binney said that we need to be clear when talking about Section 43 that its purpose is to protect parents and teachers, not children. And so as drafted, this is nothing in this section about protecting children. Justice Arbour said it clearly violates the rights to security of the person of children. And most interesting, Justice Deschamps said the court can't read the section down to create a constitutionally valid provision. So she's saying what the majority tried to do is, recognizing that it actually offends the Constitution, they tried to narrow it, to make it constitutional. So I think it's important to remember that all 3 of those judges clearly found that this violates the rights of children, and that Section 43 has nothing to do with protecting children. It's to do with protecting parents and teachers. I wonder if you have some comment on that.
Very eloquently put, Mr. Garrison. Thank you very much for that. And that leads to the confusion that Mr. Housefather was speaking to as well. We have a situation that is entirely confused. We have a Supreme Court that today, 20 years later, because of the evolution of law, understanding the science that we know about the impacts of physical force used against children, because of the evolution internationally of countries that have decided in the interests of their children and youth and their families. They need to move forward in stopping the use of physical force and punishment against children. And the organizations in Canada, healthcare organizations like the Canadian Medical Association and so many others that have all said with one voice, we need to repeal Section 43. The reality is, Mr. Garrison's point is a very valid one. We had a split decision. 20 years later, we know far, far more. And it's time to take that step to repeal Section 43 and to put into place call to action number 6 from the Truth and Reconciliation Commission. And I hope this committee will continue to further that work. Thank you.
Thank you very much for that. We will suspend for a minute because we should have 2 witnesses in the back that are going to come in the front, and we should have 1 witness to be tested on virtually. We have with us Dr. Joan Durand as a professor of University of Manitoba, appearing on her own behalf. On behalf of the Association for Reformed Political Action Canada, we have John Sakima, Director, Law and Policy, and Daniel Zekville, Policy Analyst. And on Zoom, we have representing Canadian Coalition for the Rights of Children, Dr. Kate Butler, past chair. Bienvenue à vous tous.
Welcome to all of you. You will have 5 minutes to make your presentation, which will be followed by questions by members of the committee.
Dr. Joan, if you are ready, with 5 minutes.
Bonjour and merci.
Thank you. Good morning.
This very important bill. I'll just quickly introduce myself. I'm a developmental psychologist, and I'm a retired professor in the College of Medicine at the University of Manitoba. I've spent my 34-year career studying corporal punishment of children. I've lived in Sweden extensively, specifically to study the first corporal punishment ban in the world, and I've also traveled to New Zealand several times to study their prohibition. I'm the co-author of the Joint Statement on Physical Punishment of Children and Youth, which has now been endorsed by almost 700 professional organizations in Canada. And I'm the executive director of a nonprofit parent support organization. The scientific literature is highly consistent. Corporal punishment places children's healthy development at risk. Well over 100 studies conducted across a wide range of countries and cultures have found that corporal punishment has solely negative impacts, including more behavior problems, more mental health problems, more dating violence, more intimate partner violence, poorer relationships with parents, slower cognitive development, and disrupted brain development. Some people suggest that behavior problems elicit more corporal punishment rather than the other way around. But methods have been used to address this question, including longitudinal studies, intervention studies, and very sophisticated statistical analyses. No matter the design or analytical approach, physical punishment only makes behavior problems worse, even when the punishment is mild. A meta-analysis was carried out of 75 studies of only spanking, and those punishments reliably predicted the same negative outcomes. There's no evidence that spanking benefits children in any way. If we want to promote children's healthy development, which I'm sure all of us here do, the last thing we should be doing is hitting them. This really shouldn't surprise us. None of us benefit from being hit, so why should children be any different? Once a parent starts hitting, they've raised the stakes. If the child won't comply or can't comply, the parent is very likely to hit harder. In a matter of seconds, a spanking can turn into a beating or a homicide. A large study in Quebec found that children who are slapped and spanked are 7 times more likely to be kicked and beaten and choked. 3 national studies in Canada, the CIS, showed that 75% of child abuse cases began as physical punishment. When we children, we're placing those children at risk of increasingly severe violence. When children are hit, they often become angry and resentful. In studies where children have been asked what it feels like to be smacked, they talk about wanting revenge and taking their anger out on others. They also learn that they're unworthy of basic respect. In these studies, children say things like, "You feel very little and not at all important to the world." And I don't think these are the thoughts that we want to implant in children's minds. We know a lot about discipline that does promote healthy development. Collaborative problem solving and emotion coaching are just 2 examples. These approaches give children skills to solve problems and resolve conflict. So rather than hitting them, parents learn how to strengthen children's emotion regulation. As has been mentioned, corporal punishment is now against the law in 65 countries, 2 nations, Scotland and Wales, and 16 territories. Sweden was the first. I've seen absurd claims that Swedish parents have lost control of their children and the youth assault rate has skyrocketed. In fact, serious family assaults against children declined, youth became less involved in crime, and by 2006, Sweden had the lowest rate of bullying out of 40 countries. Systematic research on Swedish parenting has found that parents are not permissive. They are less punitive, but they're no less likely to intervene. And has been mentioned, law reform is not followed by an increase in prosecutions. In many countries, reports of assaults against children increased, but that's the point, to make violence against children more visible and less acceptable. But even where reporting has increased, the prosecution rate has not.
Thank you very much, Dr. Durant.
And
You'll get a chance.
I'll get a chance. Thank you very much.
Thank you. So I should have mentioned in the beginning, due to the fact that we have 3 witnesses and many members that are going to want their turn to question. I'll do my best to keep track of time. And I will raise this as a 30 seconds without saying anything, but I will have to interrupt people when the time is up, simply trying to give everybody a fair chance. at the committee. So I will now turn for 5 minutes to the Association for Reform Political Action Canada.
Good morning. Thank you for inviting us to speak to you today regarding Bill C-273. ARPA Canada believes that Parliament must not repeal Section 43 of the Criminal Code. I want to address this topic of corporal discipline in 3 brief points. The first point, which underlies the rest of the conversation on corporal discipline, is about parental authority. The family has both natural and pre-political authority. That's why the Canadian Bill of Rights refers to, quote, the position of the family in a society of free men and free institutions, end quote. Or why the Universal Declaration of Human Rights calls the family, quote, the natural and fundamental group unit of society, end quote. Respecting parental authority and family integrity means not interfering in families, particularly through the criminal law, without clearly compelling reasons. Professor Melissa Moschella uses the analogy of intervening by force in another sovereign nation. She explains that the international community must respect the authority of sovereign states, but also has an obligation to help their people when they are in need. Coercive interference in any circumstance requires extremely strong justification, such as serious human rights abuses or threatening the peace of other sovereign states. Likewise, every political community consists of families with their own authority. Although parental authority may be imperfect at times, the state must not intervene coercively except in cases of serious abuse and neglect where parents are clearly failing to fulfill their role. As then Chief Justice Beverly McLaughlin wrote for the Supreme Court in Canada in 2004, and it's been mentioned already, but I'll quote it again. Without Section 43, Canada's broad assault law would criminalize force, falling far short of what we think of as corporal punishment, like placing an unwilling child in a chair for a 5-minute timeout. The decision not to criminalize such conduct is not grounded in devaluation of the child, but in a concern that to do so risks ruining lives and breaking up families, a burden that in large part would be borne by children and outweigh any benefit derived from applying the criminal process, end quote. My second point is that there is no adequate evidence that parents who use careful, measured corporal discipline are failing in their role as parents in a way that would merit state intrusion or prosecution of parents, which would cause serious disruption and harm children. Studies on corporal discipline often confuse the cause and effect relationship between corporal discipline and children's outcomes. Some studies assume that corporal discipline causes aggressive behavior based on a correlation. However, it could be that aggressive children were disciplined more because they were more aggressive rather than the reverse. Many studies fail to distinguish between harsh physical punishment and the measured physical discipline permitted by Canadian law. Not all forms of physical discipline are the same or have the same effects. Before criminalizing corporal discipline, lawmakers should at least have strong evidence to demonstrate that it is much less effective than other methods. However, some studies have shown that physical discipline within reasonable limits is as good as or better than many other disciplinary tactics. The outcomes for children who receive corporal discipline depend on the type of discipline, as well as whether the family has a consistent set of guidelines for when and how corporal discipline is used. Finally, my third point, other jurisdictions reveal that banning corporal discipline causes problems. For example, one Swedish psychiatrist argues that banning corporal discipline may make parents less willing to discipline or correct their children in any way. And since Sweden banned spanking, its rate of assaults of minors has increased dramatically. Examples from Austria and Germany show that parents who thought mild forms of corporal discipline were legal were less likely to resort to severe punishment than those who thought it was illegal. When no corporal discipline is permitted, parents may be more lenient until they reach a breaking point. Prohibitions on corporal discipline may also increase verbal hostility by parents and increase the number of parents who are unable to control their children's behavior. As such, permitting corporal discipline within reasonable boundaries, as Canada does, may prevent negative consequences. In conclusion, this committee should support retaining Section 43 of the Criminal Code. In doing so, this committee would align with the Supreme Court of Canada in respecting the responsibility of parents and the different ways that parents may choose to raise their children. That said, if the committee believes further clarity is needed in Section 43, the Criminal Code could be amended to include the Supreme Court's clarification about what constitutes reasonable force. These limits strike an appropriate balance that allows parents to raise their children as they see fit, while also ensuring that children are protected. Thank you again for the opportunity to appear today. We're looking forward to any questions.
Thank you very much. I will now go to Dr. Butler, video conference. You have 5 minutes.
Thank you so much, Ms. Chairwoman, for having me today to speak about Bill C-273. I'm so sorry not to be there in person, but instead I'm calling from Toronto, which is on the traditional lands of the Mississauga.
Please hold on a moment. It's very hard to hear on this side. Well, they'll tell her what to do. Is the microphone? No, it's there. Yeah. Yeah. Okay, let's start again for 5 minutes, please.
Okay, thank you so much, Ms. Chairwoman, for having me here today to speak about Bill C-273. In these opening remarks, I'm going to speak about why it's such an important step towards Canada meeting its international human rights obligations. This colonial law allowing corporal punishment dates from 1892 and is a clear violation of children's protection rights, and yet it remains in the criminal code. Canada has fallen behind the other 65 countries globally that have met their Convention on the Rights of the Child obligations by prohibiting physical punishment in all contexts. I speak to you today in my role as the past chair of the Canadian Coalition for the Rights of Children, and as a recognized children's rights expert with a PhD in sociology. I've authored numerous articles and reports on children's rights in Canada and globally with a specialization in protection rights. The CCRC is a national umbrella group of organizations and individuals across Canada who promote the rights of children and the full implementation of the Convention on the Rights of the Child. We have led the civil society role in each of the 4 UN reviews of Canada under the Convention on the Rights of the Child, including leading the youth engagement part of the most recent UN review. We engaged hundreds of young people on behalf of the federal government, and really these young people who are not here today told us that violence in the home is an incredibly important issue to them. So I just want to bring along their voice with me today. Members of the CCRC include organizations such as UNICEF Canada, who currently co-chairs the coalition, along with academics from all disciplines, Indigenous groups, health groups, and also faith organizations. As you've heard, corporal punishment refers to any form of punishment which is intended to cause physical pain to a person. It's the most common form of violence against children.
Dr. Butler, sorry to interrupt you.
Yeah.
Request from the translators, could you slow down a little bit?
Sure.
Because while you're speaking, they also have to translate.
Okay. Okay. Children are rights holders under the Convention and also under Canadian law. We don't allow for any other group in Canada to legally face violence in the home, but we do for children. This is a gross violation of children's rights. I'm here to remind all of you that you represent your constituents who are under the age of 18 as much as you do the adults, even if they can't vote. Supporting this bill is one step in the broader context of protecting children in Canada from violence. Almost 2 years ago, Canada was reviewed by the United Nations Committee on the Rights of the Child. In their concluding observations, the committee recommended that Canada repeal Section 43 of the Criminal Code and explicitly prohibit all forms of violence against all age groups of children within the family, in schools, and other institutions. They also suggested that we promote positive nonviolent forms of child rearing and conduct awareness campaigns. So Canada was called out for not fulfilling its international obligations to protect children. And I want to note that the UN committee is not the only one saying that Canada has failed to meet our obligations. In 2015, as Mr. Julian and Mr. Garrison noted earlier, the Truth and Reconciliation Commission of Canada released its summary report and calls to action. TRC number 6 states, we call upon the Government of Canada to repeal Section 43. This makes visible a complex and multidimensional problem of child violence and well-being. I also want to note that Canada is a pathfinder country in the Global Partnership to End Violence Against Children campaign. This is housed at the World Health Organization. The current Liberal government signed on to be a pathfinder country in 2018, and yet we still have not done the right thing to protect children in this country by moving to prohibit corporal punishment. This bill has support from international human rights experts. I believe you've all read the letters. In the interest of time, I think I'll keep moving. And I want to note that the violence against children is not a partisan issue. This is one that all your parties can and should support. Canada prides itself as a leader in human rights, and this is a human rights issue. Our Prime Minister has told the world that Canada is back on the human rights scene. I ask all of you to consider how this bill will allow us to comply with international human rights laws, the Truth and Reconciliation calls to action, and put us again as a leader in human rights. The Committee on the Rights of the Child has consistently called on Canada to prohibit all corporal punishment of children. Therefore, we ask you and your colleagues in the House of Commons to take the necessary steps to repeal Section 43. I look forward to questions, and I hope that my sound quality has worked out okay in the end. Thank you so much.
Thank you. Thank you very much. We will now begin with our first round of questioning for 6 minutes each. Again, I will try and be tactful with the 30 seconds, but I will need to stop at the time is up. And we will start with the Conservative Party with Mr. Van Popta.
Thank you, Madam Chair, and thank you to the witnesses for being here. We're talking about Private Members Bill C-273, which would ban corporal punishment by repealing Section 43. Now, we heard in earlier testimony today that Section 43 is codification of the common law of defense for parents and teachers who would discipline their children. And Mr. Zechveld, in your testimony, you quoted from paragraph 62 of the Supreme Court of Canada decision of 2004, which actually upheld the constitutionality of Section 43. And I'm just going to reread one sentence from there and ask you to comment on it. And this is what the Chief Justice said. The reality is that without Section 43, Canada's broad assault law would criminalize force, falling far short of what we think of as corporal punishment, like placing an unwilling child in a chair for a 5-minute timeout, close quote, or to use the example from the lively exchange between my colleague, Mr. Caputo, and the sponsor of the bill, Mr. Julian, a gentle slap on the wrist. That would be criminalized given the broad wording of Section 265 of the Criminal Code. So do you comment on that? Are we casting the net too widely by eliminating Section 43 defense altogether?
Yeah, thank you for that question. Certainly, we would say that it would, cast the net too widely to repeal Section 43 altogether. The Supreme Court has defined what kind of discipline would be allowable under Section 43, and that allows parents to use some corrective force to a child, but force that is not abusive, not done in anger, but is done for the benefit of the child ultimately.
Thank you for that answer. Now, I'm reading from a report that you have submitted, I believe, to the Senate Standing Committee on Legal and Constitutional Affairs, studying this topic, or maybe one of the predecessor bills that would ban Section 43. And you had, in your recommendation 3, you said that perhaps we could add a Section 43.1, which would essentially codify the limitations that the Supreme Court of Canada stated around Section 43. And as you heard in earlier testimony today, after that Supreme Court of Canada decision, Parliament never got around to changing anything to Section 43. So perhaps you could comment on the expansion that you propose by adding a 43.1 for clarification.
So I think this ties in to a point that Mr. Caputo was making about part of the disagreement at the Supreme Court, which I think was largely about who should be clarifying the law, not necessarily that corporal discipline should not be permitted at all. Maybe I'll just run through that really, really quickly. Justice Binney, so we have 6 of 9 judges agreeing that this is constitutional. Justice Binney agrees in the result that it is constitutional for parents, so now we're at 7 out of 9. Justice Arbour says this isn't much to go on here. This is on its face too vague, and on its face would permit severe discipline of children, severe use of force, and it should be Parliament that clarifies that. So that was Justice Arbour's position, is we shouldn't be going through and saying, here's all the things it does not allow. That should be for Parliament. Let's send it to Parliament and let them fix it. So that was much more about the relationship between courts and Parliament behind Justice Arbour's dissent. And likewise with Justice Deschamps, as Mr. Garrison rightly pointed out, Justice Deschamps said, the Supreme Court is asked to rule on the constitutionality of this provision, not to reinterpret or basically amend the provision to make it constitutional. But that's what the court did, and we can discuss whether that should have been Parliament. And I think it's helpful in certain ways to have that actually embedded in the statute for clarity. But that's really what the Supreme Court did, and Justice Deschamps is recognizing that, right? And so again, the 2 of the 9 judges, I think what's behind much of their dissent is not that there should be not any form of corporal discipline at all permitted, but whose job it is to remedy provisions that on their face are not precise enough.
Good. Well, thank you for that. I'm going to ask if you could submit your proposed Section 43.1 to this committee for us to consider. Now, moving on, I'm reading from briefing notes prepared by our Library of Parliament, our very competent analysts, and they're talking about the disagreement between research, conflicting research about whether or not corporal punishment is helpful or hurtful. And they state this, quote, two main criticisms that research on the negative effects of corporal punishment does not adequately distinguish between physical punishment and physical abuse. So I wonder if you could comment on that briefly.
Yeah, so first of all, I'll note that we have submitted a written submission to this committee as well, so that has the recommendation. To comment on that question briefly, I would point to a couple of the studies that we also reference in our written submission, which you should be receiving shortly. I'd point to footnote number 3, which has a couple studies that explain some of the methodology used in research and and how those issues get conflated. There's also a study reference there by advocates that support us.
Thank you very much, Mr. Zechfeld. You may get a chance later, but I appreciate you pointing to the fact that you already have submitted or are submitting anything in writing. And I should say for any of our witnesses, if there's anything you want to add, please do submit them in writing as well. I will now move to the Liberal Party of Canada with Mr. Mendocino.
Thank you, Madam Chair. Thank you to Mr. Julian for bringing forward this private member's bill. I appreciated his remarks at the outset. I also want to thank the witnesses for their interventions and to my colleagues across the table for their questions thus far. I would submit to the witnesses that there is broad agreement among all parliamentarians and Canadians that children are among the most vulnerable population in our country and must be protected. And that there, again, I would hope would be a very strong consensus that we must do our utmost to eliminate any violence towards them, whether it's physically, psychologically, mentally, or otherwise. And I take at face value that that is the objective of this bill. I also think that through the questions that we've heard thus far, that as a result of the Supreme Court of Canada's decision back in 2004, that Section 43 of the Criminal Code, which codifies a statutory defense when someone is charged with assaulting a child, that there have been further interpretations on the extent to which that defense might apply to someone. And so what I'd like to do in my remaining minutes is really focus on where I think there is a lively debate about whether or not any physical force is appropriate or justified to protect the child and others, including themselves, that they may harm for a variety of reasons. And so as I interpret the Supreme Court of Canada's decision, what we are really talking about are children between the ages of 2 and 12, where the force is reasonable in the circumstances to use the language of the Supreme Court, and further where the reasonable exercise of that force is trifling and transitory. So to Dr. Durant, can I just ask, in your opinion, is there any circumstance in which, setting aside the use of the term punishment, because I think that imports many of the concerns that you and other experts have in this field, but is there any physical force that can be exerted on a child between the ages of 2 and 12 that is trifling and transitory for the purposes of protecting them or others around them?
Yes, absolutely. Children need protection. That's what this is all about. What we don't want is to have them hit and slapped and kicked and punched, which is what happens in real life. Our legal system operates on the principle of discretion. Police have discretion, prosecutors have discretion, parents and teachers have the defense of necessity. I'd like you all to just think about for 1 minute the life of a group home worker, the life of a youth care worker, the life of a nurse in a personal care home, the life of people who work in childcare. None of them fall under Section 43. None of them. They cannot claim that defense. Yet they, every day, all day, are using force. They dress people. They move people. They lift people. They carry people. They feed people. They impose force on people for their care and protection. That is completely legal. And there are many defenses. They aren't dragged into court. How often do you hear about child care workers being dragged into court because they put a snowsuit on a child or they pulled a child away from something dangerous? That is care and protection. That is not what Section 43 is about. Section 43 comes from an 1860 decision in a case where a schoolmaster killed a student. He beat the child with a stick for 2 hours. The only reason that came to court was because the child died. That would have otherwise been fine.
So,
he set
Dr.
the limit
Durant,
at killing the child, and we're fortunately moving that yardstick.
So thank you for that clarification. Would you agree that a full repeal would further create ambiguity to parents and teachers through the removal of what is now not only a codified defense, but a codified defense as upheld constitutionally by the Supreme Court of Canada in a way that I think you very compellingly explained does not apply to workers? And I just want to say that what you have described is the polar opposite of what I believe to be the genesis of the Truth and Reconciliation call to action for a full repeal, which was, of course, an evil, sadistic punishment, torture that was visited upon First Nations, Inuit, and Métis children across the land. That's not what you're talking about, correct?
No, no, of course, any severe violence against a child would be is an assault. If you're worried about this, I'd like to ask you, has that child turned 2, or are they turning 2 tomorrow? If they're turning 2 tomorrow, that is already against the law. 18-month-olds, anybody below 2 years cannot be hit in any way. That is already against the law, as is hitting a child in frustration.
Thank you, Dr. Durant. I will now move to the block avec Monsieur Fortin. 6 minutes.
Mr. Fortin, 6 minutes, please. Thank you, Madam Chair. Thank you to all our witnesses for coming this morning. The information is precious. Unfortunately, I didn't see the proposal of Section 43.1 that Mr. Sekema and Zekveld referred to. I'm looking forward to reading that. I know that you're going to send it to us. It will be very interesting to see. But I would like to hear your view, Professor Durant, on this question. I like your testimony. It's very logical, and I would like to have an hour instead of just 5 minutes with you. But I would like to hear more from you about what we should do. My concern is that, yes, there is a lot of disruption in classrooms, and sometimes physical force is used to control a child. And right now, under Section 43, you can control, if not punish a child, or correct a child in a reasonable manner. But now there's a suggestion to repeal it. I think that we have to be very careful before doing so. I think we have to be cautious because we're talking about criminalizing behavior. You're talking about a mother or father who could possibly be sent to prison because of some behavior. So I think we have to be cautious. Don't you think it would be a good idea to amend 43, perhaps by adding 43.1 or 43.1 or 43B in order to clarify what is allowed and what isn't based on the decisions that have been rendered by the courts, so that parents and teachers can do their parenting or teaching job. And as far as I'm concerned, it's absolutely obvious. There isn't even any discussion about the fact that it is unacceptable to hit a child with a stick. And the example that you gave from 1916, I think it was, it's totally unacceptable that a teacher would end up killing a child. I think that we have to just clarify under 43 what is allowed and what isn't in terms of use of force on children. In your view, don't you think that would be a better approach rather than simply outright repealing 43? No.
It's a terrible idea. And the reason is this. This is the Human Rights Committee. This is a committee that makes decisions on the basis of universal human rights. Children are the only people that are not protected from assault. They're the only ones with this exemption. Think for a moment about the past criminal code. There was once an exemption in Section 43 for masters of apprentices. They could hit their apprentices. They no longer can. There was an exemption, there was Section 44 that exempted captains of naval vessels for using force to correct and discipline. That was repealed in 2001. Captains of ships cannot use corporal punishment, or in fact, that was an even broader defense. That was just force to control, keep things under control. They can't. The only people who can be hit under Canadian law are children. Children. 2-year-olds who have no defense. They're completely dependent on their parents. And I think that this idea that it's only keep the law or do nothing is a real red herring. What I spend my life doing now is helping parents learn how to manage their frustration, how to understand why children do what they do, and how to guide those children in a way that promotes their brain development, promotes their emotional development, and keeps them safe. Why would we put into Canada's law in 2024, here are all the ways you can hit a child? That would be an international embarrassment.
Je m'excuse, je ne veux pas être impoli, mais il doit rester.
I'm sorry, I don't want to interrupt you and be impolite, but I just have about a minute and a half. My colleague, Mr. Mendicino, for whom I have huge respect, talked about assault against children or punishment. I can understand that those words have a huge connotation of violence, but in 43, you're talking about use of force. So I think that such extremes, assault on a child, that's not acceptable, but I'd like to explore with you some distinctions that could be made. You're saying that children are the only ones who can be hit, but obviously we don't want that. But use of force, to me, seems much broader than just hitting. It could be all sorts of behaviors, and that's why I liked the idea of making a distinction between the different behaviors. Abolishing all use of force should be prohibited. Is that what you're saying?
No, corrective force. Section 43, correction, force by way of correction, which means punishment. Every other law like it around the world has been worded with things like chastisement or punishment. They've used that word. For some reason, when they codified Canada's criminal code, they used the word correction. It's about punishment. That law is about punishment. And the Supreme Court tried to create a new law, but they can't do that.
We'll now move to the final 6 minutes
many
on the
other
first
defenses.
round with New Democratic Party with Mr. Garrison.
Thank you very much, Madam Chair. And I want to start by saying how fortunate I think we are to have Dr. Durant and Dr. Butler here, who have extensive experience both in research and advocacy on the topic that's before us today. And I want to start with a question to both of you that's really begun to perplex me this morning as we have these questions. This is a committee that's recently dealt with coercive controlling behavior in intimate partner relationships, where we're seeking to amend the criminal code to prohibit additional forms of violence to physical violence. We've dealt with questions of elder abuse, where we have sought to make sure that elders in care are not subject to violence. And so my question to both of you, and I'll start with Dr. Butler, is I just don't understand why somehow we're having a debate today about how much violence against children is acceptable when we don't have that debate about anybody else in our society. So maybe, Dr. Butler, I'm asking you an impossible question, but it's a frustrating question for me this morning.
It's a frustrating one for me, too. I believe that when we tell children that corporal punishment is still legal in Canada, we're saying that their humanity is valued less than adults, that our convenience trumps their rights, that they have to bend their self-expression to the will of adults. Canada ranks very lowly in their peer countries in awareness of children's rights. And so corporal punishment is both a symptom and a cause in that regard. So I'll pause there because I know Dr. Durant has something to add to this as well. But yes, I agree with you. We are not sending the right message to Canadian children that we value their rights.
Yes, absolutely. We need to recognize children as human beings. And I think that comments about parental authority and so on, parents don't lose their authority when they stop hitting children. They actually gain more authority. They gain more respect. What we've learned from many studies is that when children are punished in this way, they are afraid. They become dishonest. They start to distance themselves from their parents. They don't go to their parents when they have problems because they're afraid of them. We need to help parents reduce the fear and strengthen the relationship. In other countries, there has been so much effort put into supporting parents. We need to do that in Canada. We value families. Families are the center. They are the center. Families are precious. I am a parent. I am a member of a family. And families are the source of population health. And the ultimate predictor of health is trust and attachment between parent and child. When we start hitting them, we start to erode that and we destroy that. We need to focus on building attachment, building strong families, building strong parent-child relationships, and that's what I do every day of my life. And when parents ask me, what do I do instead, I realize how poor a job we have done, that we can't come up with a better solution than hitting. Hitting is the training ground. Corporal punishment is the training ground for coercive control. And I think we all need to give some thought to the resentment, hostility, and anger that's building up in children that can't be expressed, but very well could be when they're caring for us. I think a lot of elder abuse is rooted in the experiences that children had when they were young. And that comes back to haunt us. It also, we know clearly that children who are physically punished are more likely to bully, more likely to engage in dating violence, and more likely to engage in intimate partner violence. I will never forget a woman who told me, you know, when I was a child, my father would hit me and tell me, I do this because I love you. My entire life, I only have been involved with violent men. I've been held captive. I've been choked and strangled because they tell me they love me. I learned very young, when it was embedded in my brain, that violence equals love. That set me on a pathway where that has been my entire life. We've got to come to terms with this and realize what we're actually talking about. We're talking about using violence to coerce children. We're not talking about protection. We're not talking about putting them in car seats. We're not talking about pulling them out of traffic. Oh my God, we do that every day. We do that all the time. And if we're worried about that, we should think, okay, the Supreme Court said, Section 43, no punishment of children under 2. Have we seen? Those are the children most likely to be hit, actually, because, well, we all know why. They're very active and they don't have much language. So have we seen a rush of parents into the courts of children under 2? Have we seen a rush of apprehensions of children under 2? The Supreme Court also said that hitting a child in anger or frustration is now against the law. How many parents are hitting children when they're not frustrated? Have we seen a rush of frustrated parents being pulled into the courts? No. These are all red herrings. We're talking about a principle, and the Committee on Justice and Human Rights needs to understand that we are denying children the basic, most fundamental right to protection. And Canada is a laggard. Canada is when I work internationally, which I do a lot,
thank you very much. I'm going to have to interrupt to start our second round. And again, we will keep time because we only have limited time left. And we will go to Ms. Gladue for 5 minutes, please.
Thank you, Chair, and thank you to all the witnesses for being with us today. First, I want to say that we've heard a lot today about people being choked or strangled or children being assaulted or killed. And I want it to be clear on the record that these things are already illegal in Canada today. They're already illegal. Regardless of what happens with Section 43, those things are already illegal. What we're talking about with Section 43 is what kind of protection ought to be offered to parents and teachers in the reasonable raising of the children. And so if you look at the Supreme Court decision that upheld Section 43 in 2004, and you listen to what they had to say, I'm going to read and quote here, the use of force must be sober and reasoned, address actual behavior, and be intended to restrain, control, or express symbolic disapproval. They also noted that the child must have the capacity to understand and benefit from the correction, which means that Section 43 does not justify force against children under the age of 2 or those with certain disabilities. According to the SCC decision, reasonableness further implies that force may not be administered to teenagers, as this can induce aggressive or antisocial behavior. Moreover, force may not involve objects such as rulers or belts, and it may not be applied to the head. So we know that when courts make decisions, they always talk about precedent cases. And they don't just talk about, the law. They talk about the interpretation that people gave on those precedent cases. And so I believe that the Supreme Court's interpretation, which was accepted in the majority, and honestly, from the views that we've heard of the dissenters, even the dissenters, were liking what I just read to you. So my question is for ARPA. Do you think the private member's bill is necessary, considering that the Supreme Court has already upheld this?
No, I think obviously the private member's bill would fundamentally change the law. I know there's been some discussion of what other common law defenses would then come into effect. The Library of Parliament's paper on this gives a helpful summary of that, just that there's a lot of vagueness around the de minimis defense, which has not really been applied in this context. The defense of necessity would clearly protect you when you pull a child out of the way of traffic, but would not defend you if you make a child go to a chair or stay in the chair for a timeout. That's the line that, of course, Justice McLaughlin used. And that's for the de minimis defense. Justice Arbour, in her dissent, noted that defense would need appropriate expansion to cover some of the things we wouldn't want to capture. So even in the dissenting opinion, there's a recognition that something in the law would need to change, whether through Parliament amending the law or through new judicial interpretations of that defense. So just removing this provision and doing nothing else, I think, does cause problems that the Supreme Court had a view to avoid.
And what kind of negative consequences do you expect if this section is repealed?
Well, the Supreme Court noted in its judgment the importance to balance, of course, the need of children for safety and their psychological integrity and well-being with their need for family integrity and family cohesion, and that parents would not be subject to reports, investigation, and possibly, albeit likely rarely, prosecution. Is that something that disrupts the family and is in that way damaging to children?
So, having had children myself, and I would say if you have a 3-year-old and you want to get them out the door in the morning, put their shoes on, you may find you have a struggle, and they don't want to put their shoes on, and you can ask them multiple times, but they don't, and you end up having to sort of forcibly get them on your lap and put their shoes on. So these are the kind of forcible restraints that I think people are worried about when they see repealing this section. My daughter is a teacher at a school where as we've heard, there's increasing violence, and students have attacked her when she was pregnant with a knife, things like this. And so being able to, restrain the child, to take the child to the principal's office or something, these are things that are protections for other children as well as the teachers. And so it would be concerning to me to see this repealed altogether. What would be your opinion about that, to John again?
I don't know if you have that. I don't think that removing this is the only way to deal with the abuses that children face, and that they're.
Thank you.
Yeah,
Thank you for that. And again, anything that anybody wishes to say that hasn't got any time today, please send them to us in writing. And I will now move to Madame Brière pour 5 minutes, s'il vous plaît.
Thank you, Madam Chair. Thank you to all our witnesses. I will ask my question in French. Dr. Butler.
Dr. Butler, what is the balance between protecting children against corporal punishment and the fact that it isn't in the interest of the child or our legal system to inflict legal sanctions against those who actually commit such gestures, who do inflict corporal punishment?
Thank you very much for the question. And I appreciate that you're bringing in the best interests of the child here. So first of all, I would say that parental rights are not in conflict with children's rights. Parents have a duty and they are responsibility bearers. So they need to uphold children's rights. Now, I want to take this question and think about the international context. Dr. Durant has already mentioned New Zealand, Sweden. I'd also like to mention Ireland, Wales. What we can see when we look at what has happened worldwide is that police and the justice system are not pulling in parents for these kind of situations. Instead, we're seeing that there has been many more parenting programs, positive parenting programs, which are giving parents different options when this kind of situation occurs. And also, just to note, if you read some of the letters, I believe that came to the committee, the only cases that do get prosecuted are cases where children have been beaten very severely in the home. And so having this total ban on corporal punishment is really important. And I just want to pick up the one other point, which is that we're not saying that you can never use force in a case of safety. So this 2-finger thing, if I have a 3-year-old, if she's going to touch the stove, of course I can pull those 2 fingers away for a point of safety. But I'm not afterwards going to slap her really hard on her 2 fingers. There's a difference between safety and there's a difference between punishment after. So I just want to say that.
Thank you. Dr. Durant, would you like to add something?
I think it's important that we're all aware that parents, teachers, early childhood educators, group home workers, youth care staff, everyone who cares for another person actually has a legal duty of care. If a parent did not put a child in a car seat, or did not pull a child out of traffic, or did not pull that child's hand back from the stove, they could be charged under negligence because they have a required legal duty of care. They are responsible for the care and protection of children. What we're trying to end is acts of aggression and coercion and violence against children. We have a legal
sorry, Dr.
duty
Durant.
to care.
I noticed the clocks or are ringing in chambers, and I actually need consent from all members to continue on with the next 7 minutes of this committee. Do I have consent? Yes or no? No? Okay. So thank you very much for the witnesses for coming. It's 10:08, so we were going to finish in 5 minutes. So thank you very much for coming. Anything that you would like to add, please send them to us in writing. The only thing I wanted to decide with the committee, and if we have to, we will send it in writing, is we know that Monday we will continue with this study. Next Thursday, I needed to get a bit of a feedback whether we can do clause by clause on Thursday of next week, and if so, that means Tuesday at noon, we will be seeking to receive any amendments. Would be the deadline. If no, mardi.
Tuesday for amendments.
Le jeudi, you can speak to me if you want, so that we can make a decision.
That is what we agreed to, right?
I want to confirm that that's what we want.
Yeah, I mean, that's what.
Okay, all right, so fabulous. Thank you very much. That's exactly what we will do. Thank you very much.